Please support Ms. Jackwood. My name is David Shulman. I represent the appellant in this particular matter, Deanna K. Weaver, and we would respectfully request 3 minutes for rebuttal. The issues before this court are two. The two assignments presented for review by the court. Number one, whether or not the trial court used its discretion in finding, adopting the magistrate's decision and finding Ms. Weaver in contempt for failing to comply with the 2 previous court orders issued in October 31st, 2012 and in June of 2014. The record before you on appeal establishes that the magistrate held a hearing, made certain findings of fact in that particular hearing back in January of 2015, and in making those findings concluded that Ms. Weaver was able to pay something towards her previously ordered amounts from October of 2012 and June of 2014. The magistrate did find, however, that she was disabled on disability payments through Social Security. She suffered from a mental illness caused by post-trauma as a result of 10 years of torture of the marriage with Firman Weaver, that she could not work. She was an RN, but her license had not been renewed, that she receives a Social Security amount of $733 a month, which was effective originally in March of 2013, was increased from $720 to $733 5 days before the January hearing in 2015. The magistrate found it was unusual that was the first time he ever heard that the lump sum disability payment had not been paid retroactive to her in a lump sum, that she pays $425 to $500 per month to her parents for rent. I used a higher amount, in this particular case, $500 a month, in terms of coming up with my calculations in terms of what was left over, disposable income, after you take into account her $500 a month payment in rent, her $120 a month payment in student loans, and her $50 a month payment in child support, which the magistrate specifically found she was current as of the date of the hearing. That Ms. Weaver's parents were helping her financially for all her payments, all her litigation costs, in terms of the particular fees incurred during the litigation in this particular matter, as well as the psychological evaluation that was ordered by Dr. Bowden. They had paid for that. That she was married to an Egyptian man who was living in Egypt, and from whom she was receiving no financial assistance because that country at the time did not allow funds to leave the country at that particular time, and that she'd been terminated as a waitress in May of 2013. What I found somewhat interesting in the magistrate's decision and findings was the magistrate came to the conclusion that she was able to pay something toward her court order amounts, but did not come to a specific amount of money. And I addressed that in my conclusion paragraph, that if this court found that she was in contempt of the court's orders and the trial court did not abuse its discretion, I'm asking this court to consider remanding the matter back to the trial court for the magistrate to make a specific finding, the court to make a specific finding of what she's able to pay. If she's able to pay, as the court concludes, what is that amount of money? And that was part of my argument, assignment error number 2. The court's making an order, a contempt order finding that she didn't pay the attorney's fees previously ordered, but again, the court's not making a determination of what she's able to pay. And I think that goes to the purge issue that I argued in my brief, that the court, if it finds that the court did not abuse its discretion, let's remand it to the trial court and have a finding made exactly what she's able to pay. The court knew she was receiving Social Security benefits, make an order attaching her Social Security benefits for that amount of money, so there's money coming out that could be paid towards this arrearage from the previous court orders.
Well, if we're looking at this from a contempt perspective, is that, I understand your point about wanting to know what it is that she was able to pay. But if she paid nothing, Absolutely not. And the trial court determined that she was able to pay something, no matter how small, it was $5, it was $2, just to show some attempt to meet the court's order. Is it really relevant, when we're looking just at contempt?
I think it is. I think it is, Your Honor. And the two cases I pointed out to you in my brief support my contention there. Courtney versus Courtney and Harold versus Harold, both were similar fact patterns before you in this case. One was on Medicaid, was ordered to pay $70 a month in child support, was receiving, I think, $91 in benefits from Medicaid, and after taking away for other expenses, that person was left, I think, with $56 a month. The Court of Appeals in that case concluded simple arithmetic says this person cannot make that payment, even with the disposable income left over of $50-something a month.
But it's that payment. Does it specify anything? She can't pay anything. It just sounded to me, from reading the briefs, and we haven't yet seen the transcript, like the magistrate just felt as if there was no effort made, right or wrong, that had there been the slightest effort to pay anything, that she would not have been found in contempt because of all of the things that, all the findings that we referenced, but that there was nothing.
It seems like, Your Honor, I agree with you, it seems like the magistrate was exasperated with the non-payment and just came to the conclusion, I think you can pay something. Whatever that amount is, we don't know. That's a nebulous figure, apparently, but that's how the magistrate concluded. But I believe the magistrate still erred and abused his discretion because she testified under oath she didn't have the ability to pay. And she expressed that inability to pay. She has no bank accounts, no savings, no liquid assets. If you take into account after her Social Security payments, what she's left in disposable income, not taking into account paying for a newborn child at that point, paying for her own necessaries, deodorant, toothpaste, etc., and also supporting her older child, Hannah, and what's left? I mean, is my position. What's left from that amount? Out of $50 in disposable income where she's got another child, she's got to pay for an older daughter, she's got nothing left, is my argument, Your Honor. Although it was not, I don't think that area was specifically explored by the magistrate, but what is left, Ms. Weaver, when you're done paying these other expenses, that was never addressed, I think, by the court. I think that goes to the abuse of discretion. It's capricious, arbitrary for the magistrate just to say, hey, you can pay something. We don't know what that amount is. We know you have $50 left over, but you've got to pay these other expenses. Well, what is that amount, Your Honor? What can she pay?
Well, I noticed that a part of what she said she was paying was tuition.
Well, she was paying student.
Did she get student loan?
Student loan,
Student
yeah.
loan, I meant to say, student loan. So what's your position regarding the choice that she made to pay monthly student loan as opposed to the court order support?
I understand, Your Honor. That's a choice she made. I'm paying my student loans. I know student loans, Your Honor, are not forgivable by if they're supported or federal funded. You cannot forgive a student loan. Those are always going to be with you. I'm sorry, Your Honor? Oh, they are deferrable. So she obviously made a conscious choice with respect to that and paying down her student loans. And I think it was in the record, too. She did get a tax refund. She actually had arrearages, I think, of 6,000 student loans. She put that towards, in 2012, towards the arrearages of her student loans. I'd also point out this money that's owed in court order is specifically for a van payment going back to the divorce decree in 2000, I believe in 10, that came before the court on the contempt finding in 2012, that she had not paid that van payment and that she had not paid the previously ordered contempt or attorney's fees in the prior contempt motion. So we're talking about attorney's fees and a van payment that she's not paying. It's not as though she's not paying the court order support. She was current on her support. So, I mean, I guess between paying the van payment and an attorney's fee, she made the decision to pay her court order, or her student loans versus making payments towards the previously ordered van payment and attorney's fees. But she testified at the hearing that she wasn't unable to make the payments toward those previously ordered court payments. There was no evidence contradicting that testimony in the hearing before the magistrate. Furthermore, as I pointed out in the two cases I cited, those cases had very similar fact patterns. To this particular case, the one case involved a woman, the ex-wife who cross-appealed in that case. The Court of Appeals overruled all the appellant's assignments of error in that particular case, and that was in Harold versus Harold, and the appellate court in that case found that she was suffering from a bipolar disorder. She couldn't make her payments, and they sustained her cross-appeal and found that the trial court used its discretion in finding the ex-wife in contempt of court for failing to meet her obligations. That's, again, very similar to the other case I pointed out, the Courtney versus Courtney case. Again, in that case, the appellate court said simple arithmetic indicates that this person with the disposable income left over after expenses, and that person was on supplemental supports, Medicaid, could not afford the court order payments. I think those cases are analogous. I would ask the court to consider applying the reasoning in those two appellate decisions and finding in this particular case that the trial court had used its discretion in finding her in contempt of court. And also, Your Honor, like I said, if this court feels that there wasn't an abuse of discretion, I would ask the court to respectfully remand the case to the trial court level to determine whether or not, or determine specifically what she's able to pay, and then issue the order to attach her Social Security benefits so there's no issue at that point. Thank you, Your Honor.
Good afternoon. My name is Renee Jackwood. I am here this morning on behalf of my client, Firman Weaver, who is the appellee in this case this morning, or this afternoon. It was morning when I got here, it's now afternoon. Opposing counsel this morning bases his arguments both in his brief as well as what he spoke to this morning orally to the panel, is that there are findings by the magistrate. I would submit to you that there are none. There were no findings of facts ever requested in this case nor issued in this case. What he is referring to is the magistrate's decision in which the magistrate reiterates what Deanna testified to. She stated this, she stated that. What we have here is a lack of evidence for the court to rely upon and consider in reaching their decision. Deanna said a lot of things when she was in court. She failed to bring in one exhibit. She failed to bring in one budget, one receipt, one canceled check, anything that would go towards supporting what she was stating under oath. She failed to even bring in a cooperating witness. And when you read the transcript, you'll find out that her father was in the courtroom at the beginning of the hearing. Her counsel said he was maybe going to testify, so he was excused to the hall. And he was never even called in as a cooperating witness for her testimony that she gives her parents $500 a month for her rent. What she does testify to under oath is that she is an RN. She left her license lapse. She hasn't worked as an RN since 2011. She has money to do a lot of things. She's traveled to England. She traveled to Egypt in 2014. She spent 4 months in Egypt. You don't do that on no money.
Her husband was there, right? And with whom she had a child?
Well, she stated that the reason she went to Egypt was to marry this man, which she then stated that she had married him. But you will see in the transcript that she filed her 2014 taxes as single unmarried. while she testified that she married someone in August of 2014. She testifies that her latest child is by her husband. In discovery, I repeatedly requested for information and documentation, which was never turned over. She lives with her parents, and she says her parents pay for everything, including this litigation. They paid, according to her testimony, they paid for her psychological evaluation, which was a custody determination done through the court. And then she testifies that she's taking care of her oldest child, Hannah. I would submit to you that Hannah is a minor. She is in her father's custody, has been since the divorce, and that there is a no contact order between mom and all 3 children.
Are we going to find that in there?
You're going to find that in the previous court orders. Not part of the contempt action, but Hannah is one of the 3 minor children that she pays an gross child support amount of $50 a month for.
I understand that. I just want to make sure that we're going to see that in the record that is before us in this case.
I would submit to you that there is nothing in the magistrate's decision of 2015 that's going to reiterate to you who has custody of the 3 older children. But I would submit to you that the 3 older children, as part of the divorce decree, show that they're in father's sole custody and that mom has no contact orders for them. Her child support is now up to date. As in 2015, she had paid her child support $50 per month, and it was current, and she was not found in contempt for that.
What of the argument that she was not given an opportunity to purge?
This is from a 2010 decision stating that she had monies that she was to pay to her now ex-husband. In 2012, she was found in contempt and given the option of a suspended jail sentence and ordered to pay over the next 2 years. It was the 2014 then, at the expiration of the 2 years that she was given by the court, that this latest contempt motion was filed. So she's been given the opportunity to address the obligation that she has on several fronts and for several years, yet she has chosen to do other things.
And she failed to purge in 2012.
That's correct, Your Honor. The 2014, I believe, is a 3rd contempt finding against Ms. Firman, or Ms. Weaver.
Was she incarcerated in 2012?
No, the entire jail sentence in 2012 was suspended, giving her 2 years to make the payments on. So the 2014 was a motion to impose the previous sentence as well as to find her in contempt for failing to pay in 2 years.
I'm sorry, go ahead.
No, right away. This is a question of trial court's discretion. This is a discretionary issue. We do not believe the trial court failed in its rights to look at the actual testimony and the evidence. And I think there's a vast disparity between what was testified to and what was corroborated by any substantial evidence for the court. The magistrate...
In the record, we're going to find any indication that the trial court had issues with her credibility.
In the magistrate's decision, he says, he reiterates the statements made by Deanna Weaver, and then he states, he questions Deanna's credibility and says, enough is enough. Court orders are not suggestions, they are requirements.
Well, but I recognize that there was the one issue regarding the lump sum that the magistrate said, well, gee, I've never heard of anything.
That's correct.
Before, which could, be a question. I'm just wondering if there's anything else, because if there wasn't a challenge to the credibility, the numbers are not looking very good in terms of her ability to pay.
We have no evidence that those numbers are even, the numbers are not evidenced by anything except her
but it's,
testimony.
her testimony, and there's been times when in domestic relations cases where individuals' testimony, unless it's rebutted, is accepted by the magistrate court.
And in this particular case, she testifies that she has a husband who's gainfully employed as a lawyer who pays her absolutely nothing. She and the child are on benefits from the state of Ohio, and that despite the fact that she says she was married in August of 2014, she filed taxes at the end of 2014 saying that she was single and not married.
Well, she also said that husband legally could not, in terms of international law, could not support her while she was living in the United States. And I know that there was some back and forth.
Yeah, you'll see that in the transcript.
Yeah, but if we accept that, perhaps the next step is that because he could not support her legally, that she couldn't file marriage. I know that's supposition, I'm just saying.
Your Honor, I'm not going to try to argue international law between us and Egypt because I have absolutely no clue. But I guess it just stands to reason from father's standpoint that if a husband can send her plane tickets and take her there for 4 months and take care of her for 4 months, evidently get her with child, and then send her. Only her testimony. That's all we have. Oh, just her statements that she spent 4 months in 2014 in Egypt with a man who flew her over there, and then she subsequently married, and when she came back home, she was pregnant with their child. This is a simple case with a simple argument. We ask that this court, as well as the trial court, understand that court orders are not suggestions, they are requirements. The court is trying to get Deanna Weaver to understand that when they tell her that she needs to do something, she actually needs to make forth some effort towards that. And in the face of her making no efforts whatsoever towards it, the court has found her in contempt. We would ask that decision to stand. Thank you.
Please the court, in response to opposing counsel's arguments on a couple issues here. The opposing counsel makes reference to her going to Egypt and marrying this Egyptian man. It's in the record that all the payments related to that were from her husband. That is, he paid for her to come over there, paid for her to stay there, paid for her return to the United States. So that was all monies that he expended on her behalf.
Well, I think the argument on the other side is the evidence in the record is solely the testimony. There's no corroborating, there's no evidence in it. So the fact that she even went to Europe is solely based on the testimony that she went to Egypt.
Yes, Your Honor, and I think the point there being, it's uncontroverted and unchallenged. So if there was going to be challenges, opposing counsel had an opportunity. For example, if opposing counsel didn't believe the testimony about how much she pays in rent, she could have subpoenaed and called her father to substantiate whether or not that's accurate, meaning it's uncontroverted and unchallenged testimony. So I think you have a magistrate that is accepting what he has before the court during that hearing. He's accepting it as true in this particular case. He called into question at one point her credibility, but again, there was no challenge to that specific testimony in terms of the lump sum payment, Social Security, etc. So I think if the man, and opposing counsel says there's no findings of fact, well, I am submitting that there are findings. The magistrate is accepting my client's testimony and then drawing a conclusion from the evidence he has before the court, which is her testimony, and he's making a finding, well, I find that you can make some kind of payment, even in spite of her testimony that she has an inability to pay and has no assets to make those payments. He still comes to that conclusion.
But except what she stated is true, he found that she wasn't credible.
Well, he pointed out there's a credibility issue, okay? But again, he's making a finding of credibility, an issue with credibility when there was no challenge outside of her testimony.
Okay, her testimony was that she went to Egypt. So how do you prove she didn't go?
Oh, I guess that's not her burden. Her burden is that, she got up and took the stand and swore under oath that this is it. So if there's going to be a challenge to that, it wasn't coming from her. It was obviously on someone else's part to challenge that testimony. The only challenge is cross-examination. So if there's, if you're going to attack the credibility, show me proof, right? There's no proof. I guess how do you prove that if he's paying by credit card or whatever? And so I guess that's a tough thing to challenge at that point in time. But I believe through all the testimony and accepting what she said, it's our argument it's still an abuse of discretion by the trial court to come to the conclusion that she was not that she was able to make some payment towards these two previously ordered court orders. And again, the only court orders before this court in this particular contempt hearing were from October 2012 and June of 14. Not the order of 2010. Thank you.
Counsel, I need to inform you last year's record.
Thank you.
Thank you both for your presentations today.